Mike, are we ready to start?
It's just processing. I'll give you the go when it's on.
Okay.
And
It's live now.
it's live. Okay. There we
Okay,
go.
good afternoon, everyone, and welcome to our event, Cannabis Conversation with AG Dana Nessel. Before I hand things over to our moderator, Rick Thompson, just wanted to ask you all to make sure to follow our Facebook page so you can stay up to date with our events. So Rick is part of the Cannabis Caucus Board, as well as Michigan Cannabis Business Development Group and Michigan Normal. Rick?
Zara, thank you very much. I'd like to welcome everyone to our live stream broadcast today of Michigan Democratic Party's Cannabis Caucus featuring Attorney General Dana Nessel. Just a few bookkeeping things to take care of before we jump right into it. Our format today will be approximately 1 hour worth of questions predetermined by Cannabis Caucus members, and we will have time at the end of the broadcast for questions generated through our Facebook Live chat room. So if you have questions for the Attorney General, please make sure that you're on the Facebook chat room, throw them in there, and we will definitely try and get them on. Secondly, this is the second meeting that we've had between Cannabis Caucus and the Attorney General's office. You may, during the course of our interview, hear us reference a previous meeting. That would be the meeting we're talking about. That was a private meeting that took place between Mike McCurdy, Zara Abbas, myself, and the Attorney General and her staff. Having taken care of all that business, I would like to welcome to our broadcast Attorney General Dana Nessel.
Thank you, Rick. Really appreciate the opportunity to address everyone, even if unfortunately it's under the circumstances where we have to do so virtually. But I'm so glad that you guys could convene this and that we could come together, sort of, and at least be able to talk a little bit about the work that our department has done since the time I've taken office. But let me say a few things in advance of starting to get to specifics. Firstly, I do want to let everybody know how grateful I am for the support that I received from many of you that allowed me to take this office in the first place. Obviously, your support was instrumental. And I hope that we are in a place in our state and in our nation now where we see that offices like the Attorney General, the State Attorney General, and like the Secretary of State, these down ballot races, which are largely decided at conventions with, sometimes only a couple thousand people. These are really important offices for all sorts of reasons, not just cannabis related issues, obviously, but so many issues across the board. And I hope that people will understand from this point forward how seriously we have to take the people that we select for these offices, not just in the Democratic Party, but of course, at the general election as well. I mean, these aren't throwaway offices, is what I guess I'm going to say. But that being the case, just a few things that I sort of want to put out there before we get to the issue, so that people have a better understanding of some things. Firstly, I represent, as Attorney General, it's my job to represent all of the state agencies and the state boards, the governor, the Secretary of State, and several other elected officials. And so what happens frequently, for instance, is when say, Lara gets sued, or the Department of Health and Human Services gets sued, or the governor gets sued, my office represents those entities or those actors. And so many times if you ask about a particular lawsuit, unfortunately, it violates attorney-client privilege for me to tell you, to give you inside information that's going on in those lawsuits, the exact same way that if any of you had a legal case, whether it's a civil case, criminal case, what have you, and you talked to your attorney or attorneys about your case, and then they went on TV or Facebook Live and said all kinds of stuff that were sort of private conversations between you and your lawyer, you wouldn't be very happy with that. And I actually have the exact same obligations as any other attorney has. So I know sometimes that's frustrating because you want to hear me talk a little bit more in depth about pending cases. And I legally can't. And I'm just gonna tell you a story. We had a case, or it was a policy making decision where we had provided advice to a particular client, and there were a lot of things that happened in the media, and I felt as though my client, our client, the state agency, or that was not being fairly represented in the media. So I did what I so often like to do, which was to take to Twitter to try to dispel some of the inaccurate information I saw out there. And I tweeted a bunch of stuff that were really the basis of the conversations that had been going on between my office and this particular department. Well, that did not go well for me. And I actually had a very significant actor in state government, is what I'll say, demand that I retract that tweet right away and said, I didn't authorize you to put that information out there. You're violating attorney-client privilege, and I could grieve you for this. And I was like, holy crap, that's good. Like, when you threaten to grieve the attorney general, like, is that cool? And I was trying to help my client. I mean, I wasn't trashing our client. I was really trying to help because I thought that, you know, the view of the department, which I agreed with, was really not being put out there the way it should. But lesson learned is what I'm going to say about that particular event. So I just want people to understand I'm not trying to be evasive, but I could lose my law license is basically what it comes down to when it comes to asking certain types of questions. The other thing I want to say is this. A lot of times there are things that are going on behind the scenes, as I indicated, that I just can't tell you about. Even if there's not a legal case that's pending, sometimes these are policy decisions that are ongoing and we have discussions with our clients. And, you know, again, I can't, even if we're giving sort of division level advice to our clients, unfortunately, I can't go out and talk about some of these policies if we're in the process of giving advice to these agencies about the policies. But just know this, I think a lot of times when you elect a person to office, you have to just sort of get a sense of who they are and what their value system is, and to just know and hope that when that person is behind the scenes and they are giving advice and they are making suggestions, they are trying to push that department, that agency, that governor or secretary of state or whoever they are to do the right thing in regard to whatever the values is that that person holds. And these conversations happen all the time. And I will tell you, without saying anything, you know, specific, because I can't, I've had a lot of conversations even with the governor where, you know, I'll make suggestions to her and maybe she's on the fence about what she should do. And I'll be like, I really think it's important that you do this. Here are the reasons why. And sometimes she'll change her mind. Not 100% of the time, I'm not gonna say that, but many times that happens. But I can't then come out to you and be like, oh yeah, that decision you like that the governor made, that was me, this is all me. I mean, I can't do that. So these are some basic sort of aspects of state government that I just really sort of need people to know. And then also, one last thing I'll say before I get to your questions, there are also a lot of things that I would love to be able to do, but it's just really not my bailiwick. There are so many things that they have to be legislative fixes. It is my job to defend the state, and I promised to you that I would do it honorably and ethically. And I did promise that I would not make any arguments that were just flagrantly unconstitutional arguments or that were frivolous arguments. But even when I don't agree with a policy, and even when I don't agree with the stance that a department is taking, I still have to represent that particular department. It is actually my job, and I actually took an oath that I have to uphold in order to do that, to fulfill my obligations. Now, that doesn't mean that I can't sometimes suggest, well, maybe we ought to settle this case, maybe we ought to make this offer, but my client doesn't have to take my advice. And even when it comes to like gigantic cases, you know, I think there's a perception that I can just go in and settle a case, but even if my client agrees with what I want to do, sometimes, for instance, if it involves a case that involves a lot of money, that money has to be appropriated by the legislature. So I can't just come in and say, yeah, I totally agree with the plaintiffs. We're going to settle this case. You know, legislature, write that check. I'm going to need $500,000 and I need it by Tuesday. Because what the legislature would say to me would be, yeah, that's fantastic, but now we're going to zero out your budget, Attorney General. So you still get your salary, but you have no staff now. You have no employees because we're going to take all that money on that case that was settled that you didn't bring us in on and didn't tell us anything about, and we're going to take it out of your budget. So these are little things about state government that, you know, live and learn, but I just want to make some of these things clear because I think it's, it's hard to understand sometimes until you're really involved in it. And I'm as guilty of that as many other people, because I never worked in state government before. I'd worked at the county level, but it didn't work for the state. And you do learn a lot of things as time moves on. But I will say this, I have always tried to commit to the values that I presented to all of you originally. I think if you take a list of all of my campaign promises that I made to all of you, I have tried my very hardest to fulfill as many of those as I could. And of course, that's a continuing process. But sometimes things are very hard, and that, state bureaucracy is a thing. And sometimes things that you wish you could accomplish in a month, it takes years to accomplish. So anyway, with that, I hope all that is useful information in lieu of our conversation today. But with that, we can get started with your questions.
No, I sure appreciate that. And thank you for the clarification, recognizing that as a Cannabis Caucus, we also have obligations to our constituents to ask the curious questions that they have. So we'll put forth those questions, and when you find that we may have crossed a line, just make sure you let us know that this is not something that we can adjust or not something we can talk about, and we'll move on to the next subject if that's all right.
Yeah, and I'm looking at my staff right now. Normally what happens is they kick me under the table, but they can't do that. So probably I'm looking at my, can I introduce them to you guys first?
Please do, yes.
Okay, I'm sorry. Okay, I'm going to start at least at the screen that I'm looking at. To my left is Lisa Jeminick, and she is the head of our corrections unit. So she deals with everything that is MDOC related. Next to her is Michelle Bry, and she is the head of our licensing and regulatory affairs division, and she deals with LARA, and she represents an MRA and a number of other boards. Next to her in the middle of the screen is Christina Grassi. She is my chief of operations. And then under her is David Kniezek, or at least the picture of David Kniezek. Dave, did you not shave today? What's going on?
I have been terribly technologically inefficient since going to Zoom. And so I'm here and I'm listening, but the picture looks better than the real thing. So,
all right. So David is our director of legislative affairs. So he's sort of our intermediary. He deals with the legislature and anything that we have going on. We try to work with the legislature to provide them with helpful ideas and suggestions. Again, we don't make policy. In that we can't pass laws, but we can make suggestions, and we do that all the time, and we do that through David. And many times the legislature actually will come to us and they'll say, what do you think about this bill? And they'll have us critique it to see if there are issues or problems in the law in terms of whatever it is that they're trying to achieve. So I'm very grateful that they're all joining us here today. I'm going to defer to them sometimes because remember, they are the subject matter experts. Just to remind everybody, we have about 40,000 cases at the Department of Michigan, the Michigan Department of Attorney General. So there are some things that I'm probably going to defer to them because they can give you a lengthier and more in-depth and maybe more accurate explanation than I can.
Well, thank you very much for the introductions, and I'm sure that your staff is all very welcome. Right into the questions here. You recently penned a letter to Governor Gretchen Whitmer in support of clemency for Michael Thompson, who's a prisoner in the Michigan system. Can you explain how that originated, where that letter came from, and also what are the results of that letter, if any, that you've seen?
Great. Well, first of all, credit to the Cannabis Caucus. This was a case I had heard a little bit about, but I honestly didn't know all the details. And after we had our last meeting, I asked Lisa Jeminick, could you get me all the details on this inmate, including his PSIR, which is a report that's done by the probation department when they're trying to assess. It gives you details about the crime that they were convicted of, their background, information like that, and just as much information, even his disciplinary history and while he's been in MDOC and all that information. You guys had asked me to take a look at it. I did. I was shocked. Honestly, I was horrified. And, sometimes you hear something about a particular person who's incarcerated, but then once you look further, you're like, maybe this person deserves to do a little time. But I was shocked and horrified when I looked at the sentence that this particular individual, that Michael Thompson, had received. I have now practiced criminal law, set myself up for an old age joke, 26 years, 27 years now. I've never seen anything like it. I've never seen such an extreme sentence. I've never seen anybody, 3 pounds of marijuana, combined though with a felony firearm offense and also a felon in possession of firearms, which is basically anybody who has a felony conviction. You're no longer permitted to possess firearms. But then in addition to that, you can always add, if it's a crime and in the midst of whatever that crime is, you have a firearm, you can get charged with felon in possession, which is kind of ridiculous. It's sort of 2 bites at the apple, because it's saying you get charged with having the weapons, and then for having the weapons, you get charged with another crime. So, and which is done a lot. But anyway, this sentence that Mr. Thompson received, Lisa, what was the sentence again? It was crazy. It was like 40 to 60 plus 2, I think. Yeah, 40 to 60 plus 2 on the felony firearm. That's a sentence that is commensurate with particularly heinous second-degree murder cases, someone who has a criminal sexual conduct that maybe they have their habitual fourth, maybe during the course of that criminal sexual conduct case, there was torture and an attempted murder. And I mean, I've never seen anything like that before. And then in addition to that, we looked at his disciplinary history. He had 2 very, very, very minor offenses. Like one, he wasn't in line at time, I think, and I forget what the other one was. Very, very insignificant disciplinary actions over the course of all the time that he spent in prison. And I was horrified. And I remember, I don't get to make the decision. If somebody has had a legal sentence imposed, and that was a legal sentence, I thought it was a terrible abuse of discretion, but technically it wasn't illegal. I don't have the authority to pardon a person. I can't commute a sentence. Only the governor has the ability to do that. But I certainly sent her a strongly worded letter, indicated that I thought it was her obligation under the circumstances to not just seriously consider this case, but hopefully to actually commute Mr. Thompson's sentence, meaning that he would be sentenced, I had hoped, to time served and released. And so that was my request to the governor. I know as a result, they pushed up his hearing before the parole board. And Lisa, I wonder if you could explain a little bit about the process for somebody when there's a request for either commutation of a sentence or a pardon. A pardon is where you just set aside the conviction altogether. So I wasn't requesting, it seemed as though he was guilty. He was fairly convicted. I wasn't saying set aside his convictions. I was just saying release him. And that means commuting the sentence to whatever time he'd already done. So Lisa, if you could talk about the process from here on out.
Yes. So per statute, what happens is Mr. Thompson his attorneys filed on his behalf a commutation application. I believe it was filed on January 25th. And per statute, the parole board has 270 days in which to take a vote on the application, whether it has merit or doesn't have merit. Which would have been October 25th of this year. On August 20th, they did an interview with Mr. Thompson, a parole board interview, which sometimes people refer to as a hearing. And his attorney was able to be present and advocate for him. And they will discuss and vote on his case on their September 11th meeting, which is obviously a very expedited process, given that they didn't even have to get to this point until October 25th. From that point, if they vote that the application has merit, they will have 90 days to conduct a public hearing. And at the public hearing, our office has a representative, someone from my division, who represents the people and who will ask questions of Mr. Thompson and then will read the AG's letter that she wrote to the governor into the record so that it's saved there and it's part of the consideration. And from that point, if the board believes that it should go on, they will vote again. If it should go on to the governor's office following the public hearing, that will occur. And then it will be up to the governor whether she grants a commutation.
Now, regarding that 90-day period, is that a mandatory 90-day waiting period before they have the meeting, or is that a meeting that could take place in any from 1 to 90 days within that period?
Well, there is a notice period. So there's a notice period to the prosecutor and from the county of conviction and to any victims. And so I think it would be at least 30 days. I think there's some confusion about the statute, but typically the notice period is 30 days, but it must occur within the 90.
The Bureau of Prisons oftentimes doesn't make those hearings public. Is there a request that can be made from the Attorney General's office to make that a public hearing so that more people who are interested can participate or at least view?
Those are all public hearings. So, and it's available. They're being conducted now via Zoom, and the schedule is on the Department of Corrections website. It can be found there for everyone, not just Mr. Thompson, but for everyone, and any member of the public may attend any public hearing.
You previously provided our Cannabis Caucus with a list of 15 individuals who had cases outstanding in the court system, yet we've determined, as we mentioned earlier, that there were more people that have been caught up in the system than that original list would include. Is it possible for us to receive an expanded list of those particular people who may be incarcerated, not necessarily directly for cannabis, but as a result of a cannabis crime investigation?
So let me parse that out a little bit, because that's a little bit different than the request that Mike made to our office. So what the MDOC can do is pull anyone who is serving a sentence in conjunction with a marijuana charge. So for instance, you brought up Mr. Gammo. I don't know if that's how you pronounce his name. And he has marijuana charges, and he has operating a drug house charge. So that we could pick up. I think also in the example was a marijuana charge plus a tax evasion charge. That we could pick up. For Mr. Thompson, the reason he didn't end up on the list, because he had no, it was a felon in possession charge that he was sentenced on. And so that's why he didn't automatically get picked up on the list, because it wasn't his primary charge. So the 15 that you have were serving solely or primarily on an A prefix, a first charge of marijuana possession. So they are working, the Department of Corrections, as I wrote to Mr. McCurdy today, it's kind of a resource intensive process, but they are collecting everyone who is serving on a cannabis charge, whether it was an A or a B prefix, meaning the primary or the secondary charge, plus something else. So if it registers that they had a marijuana conviction that resulted in this incarceration with, I think you also referred to it as an ancillary charge, we will be able to pick those up. It's just going to take a few weeks to get that accomplished.
That's fantastic. We appreciate all the work that you can put forth. And of course, the citizens of the state of Michigan would benefit from having that information, and perhaps for more potential commutations as we're seeing with Mr. Thompson.
And again, I cannot reveal private conversations that I've had with the governor or her staff, but I think she would be fine with me saying that I think she is aware of this matter and that her office is taking this very seriously.
Well, we thank you for your role in making her aware and for communicating to her the seriousness of this issue. Another serious issue would be cannabis's continued presence on the Schedule 1 of the controlled substance list. I know you had a big preface about how there may be some cases that you can't talk about, but there was a case in the state of Michigan that would have potentially removed cannabis from the list of controlled substances. That case was very vigorously defended by your office in order to defend the state. Can you tell us what the status is of that, or what your logic is behind that?
Well, I will say that the case is still in the process of being appealed. Michelle, we've had a Court of Appeals decision, and now the time has not yet expired for the plaintiffs to file an application for leave to appeal to the Michigan Supreme Court, correct?
Yes, that's correct.
Okay, so the case is still ongoing. Technically, it's not been closed out. And our office, as you indicated, we do represent the Board of Pharmacy in this case. But what I can tell you, because it's public information, is that our arguments did not specifically address. Sorry, my cats are fighting. It's a thing that happens a lot when I'm on Zoom. I don't know why. Just when I'm on Zoom, that's the only time that they seem to do that. But our arguments did not specifically address whether marijuana was appropriately scheduled. But we addressed the plaintiffs' specific legal claims regarding their failure to state a claim upon which requested relief could be granted. And that is what the Court of Appeals actually found. I will say this, and again, I can't, as Attorney General, I can't just say, you know what, I don't like this policy. I'm not even gonna try to defend it. And I will tell you that what has happened to me a lot, because of the fact that I have made statements in the past indicating that I'm not going to make frivolous arguments or I'm not going to make unconstitutional arguments, the Republicans in the State House and Senate have taken it upon themselves to try to intervene in almost every significant lawsuit that we have. And when they do that, they come in and they make an argument to the court that they should be able to act as a party to the case, and they get to make their arguments instead of me being the actor who represents the state, even though that's what you hired me to do when I won the election in 2018. And so I have to be very careful about cases in which I would say, I'm just not going to defend this lawsuit, because pretty soon the legislature comes in and they just completely take over my job and say, you're not doing your job, which is, in this case, to defend the Board of Pharmacy. I will say this, I have made it clear that personally, what is my personal opinion? I do believe that cannabis and marijuana should be descheduled. I certainly don't believe it should be a Schedule 1. And, I would be thrilled in the event that the legislature took this issue up. I would love to go testify before either the House and Senate. I would make public statements about my personal opinion about this. And I would like to see the law changed. That's my personal opinion. But again, I am an attorney here my department is representing the Board of Pharmacy. And the way to change the law, generally speaking, unless something is unconstitutional or there's some other legitimate legal reason for it, is to go through the legislative process. And I would support that.
Isn't there a logical contradiction between the language of the Michigan Medical Marijuana Act, the MMFLA, the MRTMA, and the language of Schedule 1? Would that logical contradiction not be enough to drive you to act?
Michelle, you want to take that?
Yeah, unfortunately, I think that gets into some of the specifics involved with the lawsuit. So I don't think that we can get into some of those discussions here today. As the Attorney General stated, the lawsuit is still pending and there still is time for an application to the Supreme Court. So unfortunately, respectfully, I don't think we can get into some of those issues.
We'll move on then.
Okay.
Please go ahead, Attorney General.
I was going to say, if you want to propose a bill, I don't know if there are any that are pending. Do we have any legislators who have taken this up?
We do have a legislator that's got a bill pending, but it's not announced yet, I don't believe.
Well, let me know when it comes up.
Okay. There's another issue that you may not have a whole lot to do with, but it's an important one to our caucus, and that would be the package of expungement bills that's currently working its way through the Senate. Now, you testified during the House of Representatives portion of the bill passage to an extent that you'd like to have some changes made to the bill. Specifically, it definitely doesn't include manufacturing and distribution or delivery and transfer on the list of items that would be expunged. Now that it's in the Senate itself and poised to have one final vote before Senate approval is achieved, what is the ability to make an alteration to that bill, or what can the Attorney General's office do to try and make a positive change to that bill so that it more accurately reflects the purpose?
Okay. Well, I'm going to make a few comments on this, and then I'm going to let David Kanizik handle the rest of that since he's the expert on that. But I will say that when I first saw the package of bills, it was very important to me that marijuana be treated completely separately than any other criminal offense, because with these other criminal offenses, we're saying, well, this individual should have an opportunity to have these matters set aside, removed from their record because it's been a sufficient period of time and we want to settle them for the rest of their lives with a record. The difference with cannabis, of course, is that this is something that now, under many different sets of circumstances, you would never be convicted of at all. It's just not a crime anymore. So I thought we should treat it completely separately from a larceny or receiving and concealing or many other kinds of things that are still crimes, even if we think that there should be a greater opportunity to expunge those crimes. So our office actually drafted a completely different bill that we then gave to the legislature. It allowed for basically automatic expungements, not just of misdemeanor, possession and use cases, but also of a variety of different felony types of infractions involving manufacture, delivery, distribution, possession with intent to deliver marijuana. And we also changed it significantly. So instead of the burden being on the petitioner to say why they deserve to have their conviction removed, the burden would be on the prosecutor to say why that petitioner did not deserve to have their conviction removed. And we put timelines in to say that if a prosecutor has not filed a formal objection within 60 days, then the court just automatically has to go ahead and expunge that particular offense. And if I'm misstating this, David, you'll let me know, but that's my memory of it. I testified, I don't know, I think a year ago or so on this. And, I tried to convince them that it was important that these matters be treated differently to allow for more expungements in this arena, although understanding that the bill, even as it stands, or the various bills still allow for more felonies to be expunged than previously. However, the House did not accept my proposal as it pertained to felony marijuana convictions. They did accept my suggestions as it pertained to misdemeanor convictions. And David, do you want to follow up?
No, I would just add, Rick, and you touched on this a little bit, just from, I think, a timeline perspective, and then the role that our office has played in this conversation. As you noted, these bills have come out of the Senate committee. They're now sitting on the Senate floor. We have a legislature that's going back into session next week for the entire month of September before they go back on recess again ahead of the November election, right? First and foremost, I think we have to point out the fact that we have never had an attorney general's office or an attorney general who has taken such a progressive stance on this issue. And so when we had the legislature express their interest in wanting to not just talk about expungements, but to also be receptive to the idea of cannabis or marijuana expungements, the attorney general was all in from day one and made sure that all of us were all in on this issue from day one as well. So from the beginning, she touched on this already, we were pushing the legislature to go farther than what they finally adopted in the House and out of Senate committee as it relates to these expungements. We're still pushing for the adoption of some other felonies to be included in this expungement package. But as you know, that's an uphill battle with this legislature, and making sure that we were treating this separately from the other expungements that are being talked about in the package, I think is really important, making sure that there's this rebuttable presumption present that, if you were convicted of this after or before a certain date, it would have been legal if you had have convicted or been convicted of that after 2018. And so what I think that we have moving forward is a really great opportunity to move the ball down the field. I don't think anybody on this call would tell you that we think it's the be all end all solution, but we certainly think it's a step in the right direction. And with the window closing here at the end of the year, I know that we want to have these bills passed and pushed as far as we can, just so that we can have these adopted into law and to begin the expungement process for folks that should not have these convictions on their records.
Well, Attorney General, I can tell you I've made a lot of suggestions to the House of Representatives that they haven't taken either. So you're not alone in that respect, I can promise. Thank you very much for your answer. Previously on our prior call, we talked about having expungement be explained in a single video or a series of videos directed from your office, because expungement right now is not uniformly applied across the state and it's not uniformly understood. And with a brand new law that is so encompassing, there are many different crimes that would be applicable for expungement now. That direction should come from your office. Have you given that more consideration? Is that something that you have on your mind?
Yeah, well, that was the suggestion from the Cannabis Caucus, and I think it's a great idea. I did say I absolutely wanted to wait until we saw what the result of the bills are, because, there's no point in making a video about whatever the current state of the law is now to only have that change in a month or two, or hope that it changes, right? I have every expectation it's going to change one way or the other. We just don't know what it's going to be yet. But once that happens, absolutely, I think it's a good idea that we put something together. I want to have something right on my website where you can click on it and say, find out how to apply for, and here's an application to set aside a conviction. Here's how to apply. Here's how you need to do that. Now, I will say the package of bills as it stands now is fairly complex. I mean, honestly, there are parts of it that are hard. So I think what our office should be doing is trying to figure out what is the best, easiest way to explain this, understanding it's hard to give what is honestly legal advice to people via our website, but we can try our hardest to say, here's what the law calls for. You can have X number of misdemeanors. You can have X number of felonies. If this, then this. If this, then this. And we can try our hardest to put something together to simplify it the best way possible, because we want to make sure that people can do this on their own. To me, if you are a well-off person, if you have a lot of resources, a lot of finances, I guess you're going to be just fine. But what we don't want to see happen is people who are the most needy of an expungement because maybe they can't, find employment because of their criminal convictions. They don't have the money to go out and hire an expensive attorney in order to, take them through this process. We want everyone to be able to do this on their own without hiring a lawyer. And so I'm committed to doing everything I can to make that happen. I'd also, if we ever get past COVID, which knock on wood will be sooner rather than later, I'm committed to having, expungement fairs where we, have presenters and sit there and we can have the forms ready for people and we go through it and assist them in that way. But, absolutely, will I put together a video? Will I put together some materials online? I am committed to doing that 100%.
Fantastic. One of the other takeaways we had from our previous meeting was our request for some kind of a hotline or an 800 number to be able to have cannabis industry individuals report variances in people's behavior. For example, business owners that are not obeying the law, municipal leaders who are not respecting the law, law enforcement officers who are policing the citizenry without proper respect for the cannabis laws themselves. And you'd mentioned that there is an 800 number that exists which would satisfy that particular need. Could you talk about that for a moment?
Well, I'm going to send this over to my Chief of Ops, Christina Grassi, and have her talk a little bit about sort of the functioning of our office. And, we get calls for all kinds of different matters. We have so many different divisions in the office that do many different things, even just what you talked about. Some of those matters would go to one division, some would go to another. So Christina, can you sort of walk everybody through how that works with our office when we have, a citizen or a resident who is calling in seeking assistance from the AG's office?
Yes. So there's two ways really to get to our office, and it's just what's more convenient for the person who wants to make the request. The first way is we have an email address that you can send complaints to. That's MIAG@michigan.gov. So MIAG@michigan.gov. And so you can just send an email to us with whatever the issue is, and it's triaged by a team inside our department. The other way you can do it is by calling our office. It's 517-335-7622. Again, 517-335-7622. Whether you send the email or the phone number, what happens is it goes to an attorney in a division depending on the content of the issue. So, cannabis issues can take many different shapes and forms, as I can tell by the questions you guys asked, right? Some of them have to do with taxes, for example. Some of them have to do with licensing issues. Some of them has to do with criminal issues. So whoever receives the email looks at it and says, well, this is cannabis, but does it have to do with tax, for example? If it does, we actually have a division that only does tax work at our department. So it goes to the tax attorney, and then they're the ones that respond to your question. If it has to do with licensing, for example, Michelle is here today. Michelle is the division chief of our licensing division. So she would assign it to one of her attorneys and they would respond to you directly. So what we try to do is have them come in and then send them to subject matter experts who can answer your question. Sometimes people ask our office questions and it really is more appropriate for our client agency. So maybe one of the agencies that we represent or the licensing agency in this issue. And what they'll do is they'll give you a contact number, name from somebody who you can get to right away who will be able to answer your question from the client. So that's the nice thing when you go into this system that we have, is we try to provide you with as much information as we can. And if we don't have it, because we work with our client agencies so much and because we know the stuff that they do, we can get you to the person at the state who can help you. And I know that's sometimes difficult for people who aren't familiar with the state. So we try to be helpful. You use whichever is most convenient for you. I apologize right now with COVID, it's been a little bit difficult. We have a significant increase in some of the complaints that are coming to our office, but we do try to get back as soon as we can.
This being an election year, there's always a trend of business owners trying to influence their employees on whom to vote for local or state or federal elections. That's not legal. And if people see activity in their workplace trying to influence their vote one way or another, is that something they should report to the Attorney General's office also?
Yes, I would say absolutely you should. And in fact, we are becoming very, very active in this space involving voter intimidation, voter suppression, the disenfranchising of voters. Many of you, unfortunately, might be aware of the fact that there were robocalls that were made into the city of Detroit just yesterday that was providing, massive misinformation to Detroit residents, indicating that if they fill out an application to vote absentee, that it can be used for all kinds of other purposes involving their credit score, or if they have outstanding warrants, and that they would go on some lists. I mean, it was crazy. The threats really that were inherent in that robocall about all kinds of detrimental activities that a resident or a voter would be subjected to in the event that they signed up to vote absentee. And of course, none of that is true. So what we are trying to do, we are handling cases involving voter suppression and voter intimidation and voter fraud or anything of that nature should come to our office. We are working hand in hand, coordinating with the Secretary of State on this issue. We're also actually working with the governor's office on this issue. So if there are those kinds of efforts afoot, please call us, let us know. Please know that we are being very, very active in this arena between now and the election, during the course of the election. And it's not just employers. I mean, honestly, we had the President of the United States make a statement about sending the military and sending federal law enforcement and sending sheriffs and U.S. attorneys to polling locations. This was an actual thing that the president said. It's 100% illegal, and not just because of one law or two laws or three laws. There might be at least a half a dozen federal statutes, another half dozen state statutes, and then the United States Constitution, for instance, that prohibit that kind of activity. So unfortunately, those kinds of statements are out there, those kinds of threats are out there, that kind of intimidation is out there. And when it occurs, we want to know about it and we will investigate it.
Thank you. Thank you for protecting that. We have a question regarding cannabis consumption in public. The drafters of the MRTMA and the language of the act itself pretty clearly indicates that being caught consuming cannabis in public is a civil infraction, like a $100 fine. But we're concerned that there are some elements within the Attorney General's office that may not agree that that's the definition of this. Can you clarify for our viewers what the status is of that, or what the official designation is?
Sure. Well, as you know, there are a number of different laws out there that unfortunately are not completely in concert with each other. Of course, we have the MMMA, the MMFLA, and then MRTMA most recently. So there are aspects of them where one might differ from another, and it creates confusion. And that's why after I got into office, we created a work group to specifically talk about these issues. And we had defense attorneys, we had the Prosecuting Attorneys Association, we had the Michigan State Police, we had Andrew Brisboe from MRA, Michelle Bry was part of that committee or that work group. And then, Sato was on the work group. We had a number of different actors that we could all come together and say, okay, where are there issues where it's not entirely clear because maybe one of these laws contradicts another law? And how do we come to a space where we can all agree on what the law between all of these things really should be and then we give that to the legislature so that they can draft a new law to make it absolutely clear. And of course, we wanted to have people at opposite ends of the spectrum so that we felt as though if we were making these recommendations, this group of all these different actors that were involved in the marijuana space, that hopefully the legislature would act upon that. I'll be honest with you, unfortunately, COVID has interfered a lot with this work group, the same way that a lot of different things that we were doing, we've had issues with because we could not all meet together. So I know it's been a few months since that group has met, but we did make a number of different proposals. And I think that was actually one of them. David, I wonder if you could talk a little bit more about the work group, the proposals, and what's happening with all that.
Yeah, it's actually a very timely question. I know that Michelle and I were on the phone earlier today, actually, on this very topic. I think the legislature acknowledges the discrepancies between, as you mentioned, MMFLA, MMMA, and MRTMA. I think I threw an extra M in there somewhere. And they want to fix that, right? And I think that they want to fix that because of the things that Rick just talked about. There's confusion, not just among the public, amongst the business community, amongst everybody. And so if there's a way for us to bring these three statutes in alignment with one another, I think the legislature wants to do that. The work group that you talked about did draft a series of recommendations that we put forth to the legislature. I believe it was back in May. And as you mentioned, just the same way that COVID has interrupted the work group from meeting, it has also interrupted the legislature's operations as well. But it was last week that we received an email from one of the caucuses in the legislature saying that they are ready to take a deeper dive on this issue. They're trying to pull in our office and others to try and bring these three different statutes in alignment with one another. So I'm hopeful that this is something that we can see action on by the end of the year. I know folks have been waiting for it for a long time. The one thing that, again, I do feel very confident in is that our office has already done a lot of the legwork of pulling together the various stakeholders to make these recommendations. In a perfect world, the legislature would take what we give them and rubber stamp it because we've done the work and we've got the experts. We all know that's not how it goes, right? But to the extent that our office has had the opportunity to have input and a say in making those changes, the legislature has them in their hands, and I'm hoping to see something introduced here shortly.
Hey, David, I was just going to say, can we get those recommendations together and make them public? Can we at least send them to the Cannabis Caucus so they know what issues we worked on and what our recommendations were?
I would usually, if asked that question, ask you for permission to do that, Dana. And so if you're cool with it, I think I'm cool with it too.
I am. I think people should know what we're working on, obviously. And like I said, we try to have all facets. We want to have as many voices in the room as possible on this. And I have to say, there was largely agreement. I don't know, Michelle, I don't know what your thoughts are on this, but almost every one of these issues, our votes were unanimous.
Yes, Attorney General, I think there were a lot of voices in the room, and I think that was great because it was a good cross-representation of the stakeholders here. And I think what we did try to do were tackle issues that we thought we could all agree on so that we could make some significant progress rather than getting caught up in some of the differences that some of the individuals might have. And I think we did make some good progress, and I look forward to those continued discussions.
And I do want to say, so we had, like I said, we had a representative from the Michigan State Police. We had a representative, well, actually we had several representatives from the Prosecuting Attorneys Association. And I was surprised at the lack of pushback that they gave the defense attorneys that were there in terms of their interpretation. I mean, they were in agreement. And I had to be honest with you, I think I don't want to speak for the Prosecuting Attorneys Association in Michigan, even though I'm on the board. And I certainly don't want to speak for the Michigan State Police, but the impression that I got was, I don't want to say they're over marijuana. That's not like the best way to phrase this, but just that they have bigger fish to fry, and that on most of the discussion that I saw was moving towards, the understanding that the voters of the state had decided that marijuana under most circumstances was no longer to be illegal. And they didn't want to have to deal with it. Basically, they weren't interested in that. I don't know if I'm phrasing that incorrectly, Michelle, but that was the impression that I got. I don't know. I don't think that speaks for every single member of the Prosecuting Attorneys Association. I don't know that that speaks for every single person of higher authority with the Michigan State Police, but that was just the general impression from their representatives. What did you think, Michelle?
Yes, I mean, I thought for the most part, people weren't arguing about whether marijuana should or shouldn't be legal. They were, the discussions were centered around how can we look at each of these statutes and see some of the discrepancies between these statutes and how can we fix those so that we can have a better understanding and so that the prosecutors understand how it should be viewed and the defense attorneys understand how it should be viewed. And I think when you have an opportunity to look at the final recommendations that were forwarded to the legislature, I think everybody will see the common ground that we found in a lot of those suggestions that we had.
Yeah, and some of them involve things like the transport of medical marijuana. I mean, there were issues, there were discrepancies between the new 2018 law and the 2008 law. Whether or not you had to have your marijuana in a locked container, what proper possession amounts were under certain circumstances. There were things that, again, there were discrepancies that really had to be worked out. And so our thought was, we don't want to have, this case go where there's any uncertainty or ambiguity, or uncertainty. We didn't want to have one judge in Genesee County decide one thing and one judge in Lake County and one judge in Chippewa County, and then they all come to different decisions. It has to go through the Court of Appeals. Everybody's got to argue about it. Then it goes to the Supreme Court, then it goes back down. I mean, why not just have the statute be as clear as possible and not have courts around the state having to worry about that, and frankly, not have prosecutors around the state charging things because they read the statute a certain way because it was so unclear. So that was really our goal. And we will get you a list so you can see what our recommendations were. And hopefully, even with COVID, I'd like to continue on with the work group and see if we can make a little bit more progress.
I'll just observe that the list of people that you said included in that group didn't include any citizen groups. So I didn't hear that at all. I'll also say the MRTMA has a supremacy clause, so there's no variance between that and the MMFLA because that doesn't have a supremacy clause. So
did you see the group of individuals that we had on there? Do you know who were?
I just heard what you mentioned. You mentioned a couple of prosecuting attorneys associations, SADA, which is the criminal defense, stuff like that.
No, we had marijuana groups on there as well. But anyway, we can get you a list of the individuals that participated so you know who was there. We tried to be as inclusive as possible.
Thank you. Let's move on. Probationers are frequently denied the opportunity to use cannabis while on probation or parole because of a reference to illegal drugs. But in Michigan, cannabis is no longer an illegal drug for adults. What can the Attorney General's office do to help probation assignees or the probation board, parole board, be more proactive in the way that they assign those duties and affect judges' decisions to allow or deny cannabis use while on bond?
Right. So I used to see this all the time, when I practiced both as a prosecutor and as a defense attorney when I'd be in court. And I used to see cases where, maybe somebody would be convicted of, I don't know, it could be a larceny crime. And they'd say, well, you can't have any alcohol and you can't have any marijuana, or you can't have any, prescription medication or what have you. And, that person who committed the crime maybe weren't under the influence of any of those things at the time they committed the crime and didn't even have a substance abuse problem. There was no, history of substance abuse by that person. And so it sort of seemed like, well, what's the point of that? Why would you do that? But the thing is that judges have wide discretion in terms of what their probationary terms are, there were a number of times, and I'm sure you guys are aware of these circumstances, where I'd have a client who had a medical marijuana card, had a condition for which they were legally using medical marijuana. And for them, this is their medicine for whatever type of situation, medical ailment they had. This is a medication that was prescribed by a doctor. And they'd say, well, no marijuana. I'd be like, well, are you going to take away somebody's blood pressure medication or diabetes medication? Why would you take that away? Because it was considered to be different to them. So, I mean, it's something that we can, that I can make public statements and urge and argue about. I don't believe that as Attorney General, I have the actual authority to tell judges what they can and can't not decide or terms of probation. I would see things all the time where judges would, be very strict about exactly where a probationer could go, or sometimes even who they could, have associations with, even though we have a right to associate with who we want, but not when you're on probation to somebody. The same way that for a parolee, the state has the ability just to come into your house and they don't need a warrant to do so. So unfortunately, we have fewer rights when we are under the jurisdiction of a criminal court. Even if that doesn't always make sense. I think that there are people like myself that can be out there saying, hey, listen, this is not a proper, you shouldn't automatically, every time somebody gets convicted of a crime that has nothing at all to do with cannabis use, that you automatically say you are not permitted to consume that. But I made that argument all the time as a defense attorney, and unsuccessfully most of the time, unfortunately. I don't know, does anybody else from my team have any suggestions on this? Lisa, what did you see with that, with MDOC with that?
Well, there was a big debate. So I actually was the administrator of the Office of Legal Affairs at the MDOC at the time that everything changed. And the question was, how are we going to handle this with parole, primarily parole, but certainly they handle certain probation cases too. And ultimately it was decided, I mean, the terms of parole are that you can't break any law, and it still remains unlawful to use marijuana, cannabis, under federal law. But what they did was change their practice and policy, and they no longer were doing random drug tests for THC. Unless that person's crime was a violent crime associated with marijuana. So, and that was a handful of cases. And so they just really changed their approach to it. And there's new policy language that I'm going to send you a link to the public hearing schedule. I will send you a link to that policy, or send you a copy of the policy as well, that gave direction to parole agents on how they should be treating the use of marijuana. But ultimately, the MDOC recognizes that it is legal in Michigan.
Now, your predecessor, Bill
So that's I was just going to say that's, and I'm not going to take, I would love to take credit for that, but I had nothing to do with that. And it happened before I came to the office that decision was made. But that is the kind of thing, though, that when we talk about being able to have a little bit of influence over the departments that we represent, that's an example of something that could be done. Again, wasn't done by me, but where we can have influence in small ways. When you say what can be done, I guess things like that. But in terms of what the judges in counties all over the state, and in district courts and circuit courts all over the state decide to do, all I can do is make public statements. I don't know that I can actually do anything as an attorney general, except for to make policy related statements that I hope that some judges will listen to.
Your predecessor, Bill Schuette, took a lot of criticism for the small number of Attorney General's opinions that he issued during his tenure, but the opinions he issued were used to great effect. What about the role of issuing Attorney General's opinions to clarify some of these obfuscated issues across the state? What would be required for you to be able to engage in that?
Well, first of all, I think it's important for people to understand some of the limits of AG opinions. Firstly, in order to request an AG opinion, I think, these requests can't be just from, I'm a citizen in this state and I want to hear what the AG has to say about this. Generally, it has to be, say it's a state agency that we represent, or a state department, or a member of the legislature. And in fact, most of our requests come in from the legislature. We also have requests from the Secretary of State and from the governor that we've responded to. And so some of the opinions that we've issued as of late, one involved the Mackinac Corridor Tunnel Authority. One involved changes during the lame duck period to how ballot proposals were handled and how many signatures you could get from a certain area. We have a opinion that we issued involving guns at the Capitol. There was a request made from the Democratic leader in the House in regard to that. But generally speaking, again, that's where those requests have to come from. What we, in choosing what opinions we author, one of the things that we think is very, very important is that generally it be something that, because our opinions, they're binding on our state agencies, but they are not binding on the courts. So the courts can accept our opinion and follow our opinion, or they can reject it entirely. And one of the things that I wanted to avoid happening is I did not want to be the next Bill Schuette in so many different ways. But one of those ways was the fact that I saw that a lot of his opinions were totally disregarded by the courts. And so it really minimizes the impact and the effect and the importance of these opinions when the courts don't respect them. So I honestly didn't want to just say, well, I'd like, and I was very clear with my staff from day one. I don't ever want to be in a situation where I say, I disagree with this policy, let's find it unconstitutional. You know, I wanted to make sure we were always on firm legal grounds, or I did not want to issue that opinion at all. And there have been many times, by the way, where someone has asked us, you know, well, I'm one of these actors that, you know, is in a position where legally they can't ask us this question. We'll say, well, you know, I'm thinking about asking for an opinion on this. And sometimes, you know, we'll do the research and say, you can ask, but you're not going to like the answer that we give you. Because I'm not going to do that. I'm not going to give a legal answer that is not on firm legal grounds just because politically I happen to agree with whatever the position is that somebody wants me to conclude in one of our opinions. So that being the case, we generally like to ensure that these opinions have an impact on our state agencies because, again, they are binding on those agencies. So, you know, that's the way that we've been approaching these, and that's why we don't take a whole lot of them, because we want to make sure that these are not just really important cases, but that this is the best way to move an issue forward, and that we're doing it on solid legal grounds. I don't know, Christina, maybe you want to address this, or David, maybe you want to address this, because we've had a lot of conversations about our AG opinions.
Yeah, I mean, the only thing I would add, I mean, you kind of hit the nail on the head. What an AG opinion can do is really bind state agencies. And, you know, with the current administration, I think oftentimes we can have the effect that we want just by talking to our state agencies and asking them to look at something rather than issuing an opinion. But, you know, we can't bind local actors, for example, or local courts or local governments, or, I mean, they're really intended to clarify areas of the law for our client agencies. The legislature sometimes asks us about issues that are relevant to a local jurisdiction, and we'll issue an opinion. But it's not a cure-all, and I think sometimes people think it is, because we can issue opinions and speak, but it's most effective when we're counseling our client agencies about something. We have, by and large, pretty good relationships with our client agencies, and so if they're doing something that we disagree with or we think is not following the law, it's much faster and easy for us to just talk to them and say, look at this issue and think about doing it a different way. So there's just limits to it. I don't know that it's a fix in every situation, but you know, it's also hard to have access to somebody who has the authority to issue an opinion, like the AG said, because not everybody does. A lot of people can write their state rep or state senator and they never hear back, or that person won't send the request. So it's hard. It's a narrow avenue into the AG's office, and it doesn't have, I think, the broad impact that some people do. It is helpful in sometimes, and we do look at it, but my frequent interactions with people is it's not really what they think it is when we talk about it, but it's something that we do consider doing, and certainly this Attorney General is interested in doing it in the right circumstances.
And sometimes what we offer to do, I mean, we've had times where people will ask for an AG opinion, and I'll say, I don't really think it's appropriate under these circumstances, but I do agree with the point you're trying to make. And so my department will file an amicus on behalf of whatever the particular entity is. And we've done that on a number of different occasions where we will file an amicus. That's different than an official AG opinion, but we are still willing to do it in a variety of circumstances.
We're just almost to the point where we're going to start taking questions from the chat. But before we do that, what's your vision for the next 2 years of your administration? What are the big goals you want to accomplish in 2021 and 2022?
Firstly, I'd like to leave the House. And secondly, I want to fit into the clothes that I could wear before COVID hit. So I would say those are maybe my two biggest goals. But beyond those goals, I'm sorry, when I envisioned being in office, honestly, I didn't think that I'd spend all of it in my living room. I mean, this is a crazy set of circumstances. So I will tell you a little bit in terms of, we are still out there working our hardest at our department to do everything we possibly can in regard to all of the things that I talked about when I ran for office. And whether that is just general consumer protection related matters or environmental cases that really have never been brought by the Department of Attorney General in our history that we're being very aggressive on. Whether it's going after sexual predators and our clergy abuse cases or our public integrity cases, which we have a lot of. I mean, there are so many areas where we are still pushing forward and we're trying our hardest to do our best. However, if you talk to anyone who has been in our office a long time, I was just talking to one of our bureau chiefs yesterday last year I gave him his 25-year award. It's the only place he's ever worked, and he's worked there under 1, 2, 3, 4. I'm his 5th attorney general that he's worked under. No one has worked under more than that because you'd have to go back to like 1812, I think, to get to 6 attorney generals because Frank Kelly was there so long. But that being the case, he said to me that in his career, he has never, ever, ever seen the influx of cases that our department has had to work on at one time. And that's because we're doing so much that is COVID related that nobody had, there was no way for us to anticipate that this would have occurred when I ran for office. And sometimes I look back and I'm like, maybe I should call up Tom Leonard and be like, do you want this gig? Because maybe is it too late?
Don't you do that.
No, but because I mean, this is the kind of work, I mean, no one could anticipate it. So we are so busy working with the governor on all her executive orders and then defending those executive orders in court. That is a huge amount of work. We are, in terms of the consumer protection space, whether it has to do with price gouging issues or scams or cons that are related to people who are preying upon those that are worried about saving their lives because they know that they're at risk due to COVID. And then every single division this impacts, with Lisa's division, with MDOC, you may have heard that there are some COVID related issues related to MDOC that, I'm sure when I asked Lisa to come back to the office and be the chief of my division, maybe she would have reconsidered if she would have known that she would have to deal with all that. So I only say that because I wish I could say that all the COVID work doesn't interfere with anything else that we're doing, but it's our main priority right now because thousands and thousands of people have died in our state. Well over 6,000 people have died. So my goal in the immediate future is to ensure that I am supporting and helping to draft and helping to enforce policies that mitigate the number of people who contract and who die from COVID. I don't know, I would say there's nothing more important than that, but there's one more thing that is more important than that, and that is this upcoming election. So again, I touched on it briefly, but when it comes to election security, when it comes to the suppression of votes, when it comes to intimidation of voters, that's something that is incredibly important. So we are working on that, and I will tell you that I am constantly in discussions with the Secretary of State and the Governor's Office about how best to ensure that each and every eligible voter in our state has the opportunity to vote, has the opportunity to vote safely, and that their vote is counted. So that is a huge endeavor because we are having to ward off all kinds of issues all day, every day. And some of those are cases that are filed in the courts. Some of those are the types of robocalls that we've seen coming in. Some of it is just me suing the United States Postal Service because we have a Postmaster General now who is committed to making sure that no one can vote via absentee ballot. That's a case, if you would have told me when I ran for office, those of you who saw me during the campaign, which is probably everybody who's watching today, you heard me talk about suing Betsy DeVos, which we did. I mean, won a case just the other day, and it was amazing. Anyway, and suing the EPA, and suing the Department of Health and Human Services when they infringed on the rights of individuals who lived in our state. But did I promise to sue the Postmaster General? No. Did I think I would ever have to sue the Postmaster General? I did not see that coming. It was literally not on my bingo card, is what I'm saying. So I am trying my hardest to fulfill all of the promises that I made to all of you and to everyone in the state of Michigan. And I do believe that we've made an incredible amount of progress. And if we had more time, I would start listing off all the things that we've been doing towards that end. But has our work been interrupted by everything related to COVID and then related to the election? To a great extent, it has. But right now, those are my two biggest, and frankly, I don't know what is more important in terms of this office, in terms of this department, in terms of me being a state elected official than saving democracy. So that's sort of what I'm focused on right now: saving people's lives, saving the democratic process, ensuring that everyone has an opportunity to vote.
What are you going to do after breakfast?
So,
in our chat and in our conversations with other attorneys, there's a lot of concern about countywide prosecutors still aggressively pursuing cannabis issues, even though it's been de-emphasized on a statewide level. Can you explain to our viewers the difference between county prosecutions versus state prosecutions, and what your bounds are when it comes to telling them, stop it and cut it out, you bad man?
Rick, I really appreciate that question, because I think that for people who aren't attorneys, and even sometimes for people who are, there's a lot of confusion behind this. So yes, technically I am the state's top law enforcement official, but we have 83 county prosecutors. Every single county in the state has a duly elected prosecutor elected by the people of their county. And I have statewide jurisdiction, statewide criminal jurisdiction and civil jurisdiction, which means I can go anywhere in the state, and if I want to file a criminal case, technically I can, whereas the county prosecutors can only file a case in the county in which that particular offense occurred. However, how it generally works is that, there are certain types of cases that come to us sort of organically. There are certain types of cases where we sort of go around the state and tell the Prosecuting Attorneys Association, hey, if you see a case like a payroll fraud case, those are not cases that, generally speaking, a county prosecutor will handle. Obviously, environmental law, that's not something county prosecutors don't generally prosecute environmental crimes. That's something that we would do. Consumer protection related crimes, that's something that we would do. It's not usually a county prosecutor. But if you're talking about your sort of traditional narcotics related cases, if you're talking about your, rapes, robberies, murders, larcenies, those cases generally will go automatically from local law enforcement to the county prosecutor. And again, they are duly elected by the people in their county. They can charge as they see fit. Sometimes we will come in usually at the request of law enforcement, not entirely so. If a county prosecutor has declined to take a certain case, sometimes we'll come in and we'll take that case. Sometimes they ask us. They'll just say, right, to us, we would appreciate you taking this case. Maybe it's a multi-jurisdictional case. Maybe it's a case that would involve a lot of resources. I'll give you an example, the Larry Nassar cases that were handled by the AG's office. I mean, there were hundreds and hundreds of victims. And it wasn't just one county. You had cases in Ingham County, you had cases in Eaton County. So those prosecutors actually asked the AG's office, will you take this? Because we just have more resources at the state than you have at the county level. So the AG's office took those cases. But we can't stop a county prosecutor from taking a case. We can't stop a county prosecutor from charging a case. We can't tell a county prosecutor what they should or should not charge in a case. That's their prosecutorial discretion. Again, we can take a case if they decided not to charge a case, we can certainly go in and say, well, we're going to charge that case. And what we do a lot of times, and I'll tell you, our public integrity cases, we say, hey, listen, if you have an officer involved shooting fatality, if you have an in custody death, perhaps the best place for that to go is to the state and not for the locals to handle, because the local prosecutors work so closely with the law enforcement officials that they would then have to investigate and potentially prosecute. One, it sometimes can create the appearance that they're, partial and they're not completely objective and unbiased. But two, they got to go to work with those people the next day, and it creates friction in that relationship. So for many different reasons, I have said those cases should come to us. We are handling far more of those cases than have ever been handled. I think in the history of the department, I'm going to say, partially because I have made that request. And so county prosecutors and local law enforcement are just sending those cases to us. So we are handling a lot of those cases right now. But generally speaking, I really don't have the ability to tell a county prosecutor what they should and shouldn't do. And there are a lot of times where there'll be a case where I would never, ever, ever charge that case, but the county prosecutor decides to do so. And, if it's an overstep on their part, then they have to be held accountable by the public. And I will say, I'm just going to give you an instance. I did not see eye to eye with Jessica Cooper in Oakland County on many, many different things. We had a lot of differences. So when she came up for re-election, I supported her opponent, and her opponent won. And I think that if Karen McDonald wins in the general election, I think she's going to be a fantastic prosecutor. But I think the people of Oakland County saw that she was really not doing any favors for the residents of her county in terms of the way she would utilize her charging discretion. So they're going to get themselves a new prosecutor. So I don't know if that helps to explain things a little bit, but if you have any follow-up questions, if I didn't properly address that. I rambled on for a long time though, so it ate up a lot of time.
Essentially, there are two different levels of prosecution. There's a county level, there's a state level. You are just not able to stop over that line whenever you feel like it and just stop people from doing what the citizens in their county have elected them to do.
That's right. I don't have the authority to do that. Correct.
We're receiving some questions in the chat about testing for cannabis, both in employment and also in medical scenarios too. Now that it's legal in the state of Michigan, why are we still testing state employees and others for cannabis? And what can you do about it?
Yeah, I hate that, by the way. It upsets me a lot. I am not a fan of that. And my understanding is, unfortunately, it's still part of the civil service rules. Christina, can you elaborate on that?
Yeah, I don't know if it's a civil service rule or if it's just a policy, but in the private sector, there's not much we can do about it because, a company can decide what they want, what kind of protocol they want. I came to the state 10 years ago and it was drug tested, and I think it's still the case that you're drug tested. I don't know why. I guess we've never really thought about it. I certainly can inquire and see if they want to revisit or if they thought about revisiting that policy. It does create issues. When you have a substance that's legal and you're testing for it, it can create a lot of difficult issues for people. So it's a great question. I probably should ask. I've never thought it before, and I will.
I will say, before Christina had her current position, I did look into this, and I was told that it was a requirement through the Civil Service Commission, because we had someone who applied to work at the office, seemed like a great candidate. They failed their drug test because they tested positive for THC. And I was told I was not allowed to hire them, and that was the reason why. Now, right after this, I promise you the first thing we're going to do is re-examine this. But I was told I didn't have any discretion when it came to that, and that every single person has to be drug tested in the office if they want a job there, except for me. I didn't get drug tested. You can't drug test the Attorney General. Isn't that amazing? I'm just saying, not saying that I would do anything that you shouldn't do. technically I'm the only one in the office because I was elected to that position and not hired in through the state. Is that a bad answer? I should not have said that.
No, you're good. The news flash is someone told Dana Nessel no, and she listened. Oh, what happened?
I
So
know.
maybe this is a good place for an attorney general's opinion. I'm just going to throw it out there. Our our other questions from.
That's interesting. I will commit to you, Rick, that we're gonna look into that. I promise you that we will do that.
I appreciate it. On behalf of the caucus and the state, I appreciate that. I know we have just a brief amount of time left, but there's questions regarding the mechanics of the expungement bill that's proposed, and I'm not sure if perhaps Mr. Kniezek could potentially let us know. There's questions about how many felonies would potentially be expunged and how many people would potentially be affected by the package of bills.
I don't know that we have a number in terms of total people that would be affected by it. And to be candid with you, Rick, I don't want to give you the wrong number as it relates to felonies and misdemeanors and how they interact with one another. So what I'm happy to do is, in addition to those, the document that I'm going to send to your organization, I'll also include the breakdown of that information as well for you.
That is wonderful. I'm not familiar with this case, but I'm receiving a question in chat about the Mackenzie Cochran case. And this is probably the last question we have time for today. I'm not sure if anyone on your team is familiar with that case and could comment.
Anybody? I'm not. Does anybody on our team know about that case?
I don't, but if you give me some details, I could find out.
Yeah, all I have is the spelling is Makenzie and last name Cochrane. So I apologize. I wasn't given more information than that from the chat.
That's okay.
I appreciate it.
COCH.
Yeah, I can go ahead and send you that. I'll just go ahead and email them the name and everything.
That would
Thank
be
you.
fine. And is there something specific you want to know about this case?
It specifically asked about a public update on that case, and I really unfortunately don't have more details on that.
Do you
Okay.
think whoever wrote that in can just can they give us any more information on it?
We'll forward it to you. I'm certain that the woman that wrote this will be able to do it because she clearly is intimate with the case itself. So we'll be able to get that to you.
Great.
Listen, concludes our broadcast for today. I would really like to thank the Attorney General, Dana Nessel, and her entire staff for being here with us this afternoon. What a frank discussion we've had, and how open you've been with us. We really appreciate it on behalf of the citizens of the state.
Well, I want to thank you for allowing me and my staff to talk to you in this forum, and again, hopefully in person again one day. But thank you for all the good work that everyone involved with the Cannabis Caucus has done to make, I think, this state a little bit more fair and a little bit more just. And I know you're not done yet, neither am I. So I want to thank all of you.
Thank you for that. And on behalf of the Michigan Democratic Party's Cannabis Caucus, I'd like to conclude this broadcast. Thanks to all of our viewers, thanks to our participants, and thanks to the caucus executive committee members that have been present today too. This concludes our broadcast. Thank you, and have a wonderful day.
Thank you.
Thanks.